Ready, start. It is apparent from the findings of the tribunal that the respondent number 7, took the incident personally and forcefully confiscated the keys of the motorcycle and ordered the appellant to report to the guard room. Full stop. The tribunal also notices that he was taken into custody. Full stop. The tribunal also recorded that at the instance of respondent number 7, the appellant was locked in the cell. Full stop. While deprecating the conduct of respondent number 7 for adopting such a severe action over a trivial issue, the tribunal opined that the officer of a rank of squadron leader could have given a proper advice to the appellant, to rectify his actions, keeping in view the high discipline and dignity of Air Force. Full stop. However, the manner in which respondent number 7 conducted himself was not appreciated. Full stop. While deprecating the conduct of respondent number 7, the tribunal also came to the conclusion that the appellant was subjected to harassment and humiliation, giving an impression of vindictiveness at the instance of the concerned officers. Full stop. It is for this reason the tribunal had no hesitation in setting aside the punishment. Full stop. The tribunal set aside the order of admonition dated 18/1/2011. Full stop. It also set aside the order dated 28/4/2011, whereby the appellant's statutory appeal had been dismissed. Full stop. Lastly, the tribunal also set aside the order dated 6/1/2010, wherein the Air Force commander had rejected the appellant's representation. Full stop. Thus, the decision and the findings of the tribunal have attained finality. Full stop. However, for reason that the tribunal rejected the prayer for compensation, the present appeal filed by the appellant. Full stop. We have gone through the material on record, findings of the tribunal and noted the submissions of Miss Vansaja Shukla, learned counsel for the appellant, and by senior counsel for the respondents. Full stop. The initial service of the appellant for 14 long years, from its commencement in 1997 to 2011 was unblemished. Full stop. This is an admitted fact. Full stop. From the unfortunate incident on 17/5/2010, the appellant's life was embroiled in defending in the disciplinary proceedings and contesting the case before the tribunal. Full stop. The disproportionate measure adopted by the respondents, the assurance of expunging the admonition, withdrawal of the same, and then the retrial, leading to imposition of the punishment, caused great amount of distress. Full stop. It found that the matter was escalated beyond proportion, and there is also an element of vindictiveness in the action taken against the appellant. Full stop. More than anything, the lone battle of the appellant against the unfair and arbitrary treatment meted out to him, we think is the cause and reason for the indignation. Full stop. The institution did not protect him, instead it put its full force behind respondent number 7. Full stop. Fortunately, the tribunal set the record straight. Full stop. Counsel appearing on behalf of the appellant has submitted the financial loss that has occurred to the appellant and prayed for appropriate compensation. Full stop. Small excesses like overtaking the vehicle of one's senior at a railway crossing may be an incident of indiscipline in defense services, but the balance and proportion that needs to be maintained between such an infraction and its punishment will always be at the core of good governance. Full stop. If the balance is not maintained, the distinction between bad governance, impropriety, unfairness and inhumane treatment is not much. Full stop. The tribunal is right in that a small incident has unnecessarily grown beyond proportion. Full stop. When the institutions that we willed grow beyond proportion, officers act mechanically and many a times helplessly, ignore the simple and readily available remedies that are available in our normal lives. Full stop. We would have thought that an incident like this would have ended if a senior officer had at the right time intervened and resolved the issue by taking into account the emotional aspect of the dispute. Full stop. Perhaps a simple apology by respondent number 7 would have gone a long way, comma, but that did not happen, comma, and we are now called upon to assess the economic value of the indignity and proceed to grant monetary compensation to him. Full stop. We are aware of how insignificant the monetary value of loss of dignity could be, comma, but legal remedies that they are, comma, enable us to settle it only as a measure, comma, a token of our concern and in recognition of a citizen's identity and dignity. Full stop. Having considered the facts and circumstances of the case and having noted the specific and clear findings of the tribunal, comma, we direct the respondents to pay an amount of rupees 1 lakh to the appellant towards compensation for having suffered an unnecessary and a long drawn litigation that was foisted on him. Full stop. The amount may be paid within a period of 30 days from the date of this order. Full stop.